Please proceed.
Thank you. Good morning, Mr. Chairman, members of the committee. Kristen Erickson on behalf of the Nevada District Attorneys Association. I'm here today in opposition of AB136, and with me today to express our concerns is the president of the Nevada District Attorneys Association, Chris Hicks. Mr. Hicks is the district attorney of Washoe County, and with your permission, Mr. Chairman, I'll turn it over to him.
Thank you, Ms. Erickson. Please proceed, Mr. Hicks.
Thank you, Mr. Chairman. First off, I just want to thank the committee for allowing me to testify today. It's an honor to speak here. In addition to my role as the Washoe County District Attorney and the President of the Nevada District Attorneys Association, I also serve on the committee to study evidence-based pretrial release that Justice Hardesty so aptly spoke of this morning. I've been an active participant in it, and I can tell you as I sit here today, I am neither a lover nor a hater of the pretrial risk assessment tool process. All along, I have been fully open to examining its flaws and also looking into its benefits. The reason I feel I need to speak to you all today is this bill, Section 3, requires the use of a pretrial risk assessment tool, so naturally that intersects with the work that the committee's doing and the pilot program that's going on in Washoe County. Initially, I'd like to commend Justice Hardesty for his hard work and his leadership in this committee and bringing these stakeholders together. As you heard earlier today, the usage of evidence-based risk assessment tools is compelling. The idea of using evidence-based factors to help ensure that arrestees who represent a low risk to reoffend and a low risk to not appear in court and who is appealing. You know, in those situations, those people should be considered for an OR release or should be considered for an appropriate bail by the court. Additionally, the idea of using those same factors to ensure arrestees who present a high risk to reoffend or a high risk to not appear in court is equally, in my opinion, more compelling as to why to use one of these tools. The problem that I'm here to talk about is one of the most critical factors that is considered in a risk assessment tool, and that is criminal history. And that's not just me here as the prosecutor in Washoe County, the elected district attorney. That is what the experts will say, is in using evidence-based factors, criminal history is a necessary consideration as to whether or not someone will reoffend or fail to reappear. A quick background on the Nevada criminal justice system, or criminal history system. In Nevada, the Nevada Criminal Justice Information System, or NCJIS, as some of you might have heard it called before, is what reports an arrestee's Nevada criminal history. It is an arrestee's rap sheet, for the lack of a better term. It identifies a suspect's arrest dates, the charges booked upon, and if available, record of conviction or other dispositions such as deferral or dismissal. When using an evidence-based pretrial risk assessment tool like the one being used in our pilot programs, which would naturally be the one used if this bill passed, it is what is used in scoring that sheet. So several questions ask about an arrestee's criminal history. The only mechanism in which the court services has to score that is by using that individual's criminal history from NCJIS. While NCJIS arrest records or criminal history records regularly show arrests, it is very often that they show no disposition data. So simply, an arrestee's criminal history often shows all that he's ever been arrested for, but it never gives a result. I shouldn't say never. It often doesn't give a result. This creates an overwhelming problem if an evidence-based assessment tool relies on dispositions. The tool being used in our pilot programs relies on this disposition data. So, as simply as I can put it, if the criminal history conviction data is incomplete, then so is the final score on the tool, and in turn, the release decision made by the court is poorly informed, if not misled, and potentially unwarranted. it results in making a decision in the dark. I would like to give you a prime example that is reflective of this, and it will show simply why Nevada is not ready right now for this kind of a mandate of a risk assessment tool. John Doe is the name I'll assign to this arrestee to keep his identity confidential, but he's an individual that's currently being prosecuted by my office for trafficking in a controlled substance, methamphetamine. He has a Nevada criminal history dating back to 2004. His criminal history in California goes all the way back to 1984, where he was initially charged with rape. In the last 10 years in Nevada, his insidious record reflects the following arrests. November 2015, DUI second offense. September 2013, domestic battery first offense. March 2010, felony conspiracy to commit robbery. September 2009, trafficking, possession of a controlled substance for sale, and possession of a controlled substance. April 2009, DUI first offense. January 2009, DUI first offense. September 2008, DUI first offense. December 2007, DUI first offense, drugs. Of all 8 of those arrests listed in the last 10 years, there is only one disposition in that criminal history. That's it, one. And that sole disposition is the November 2015 DUI conviction. The remaining 7 are solely memorialized as arrests. Prior to being elected Washoe County District Attorney, I personally prosecuted John Doe from charging decision to sentencing. So I'm well aware of who this individual is and what his criminal history is. His DUI arrests that I mentioned all resulted in convictions, one of which was a felony third offense enhanced by the others that put him in prison in 2010. The September 2009 drug arrest resulted in a conviction for possession of a controlled substance for the purpose of sale, methamphetamine, for which he was also sent to prison. The September 2013 domestic battery charge resulted in a plea to disorderly conduct. The conspiracy to commit robbery arrest stemmed from a 2004 cold case murder where John Doe assisted 2 individuals in the robbery of a local man who was shot during the robbery. Both the robbers were convicted of murder. John Doe received a plea deal in exchange for his testimony against the others. Unfortunately, he fled the state before the trial of one of the murderers, resulting in the court issuing a material witness warrant for his arrest. He was sent to prison in that felony as well. John Doe's insidious criminal history record shows 1 misdemeanor conviction over the last 10 years. His true Nevada criminal history over the last 10 years is 5 misdemeanor convictions and 3 felony convictions. In his entire 30-year criminal history, he has 7 felony convictions. John Doe recently pled guilty to his pending trafficking charge. He's stipulating to a 20-year habitual criminal sentence. The John Doe case is merely one example. I could personally provide many more. Given the systematic problems with the timely entry of data into the criminal databases, I estimate there are hundreds or thousands of John Doe cases for which the current pretrial risk assessment tool will produce wildly misleading scores. If you score John Doe through the tool being used in our pilot programs, using the woefully deficient insidious conviction data, he scores in the low, moderate risk, meaning he's a low, moderate risk to reoffend. He's a low, moderate risk to fail to appear. Upon judicial review, he would likely be given an OR release with limited supervision conditions. This is a man with 7 felony convictions, 3 in the last 10 years. They include violence resulting in a murder, drug dealing, and habitual driving under the influence. But the evidence-based assessment tool would not show any of that. It would reflect 1 misdemeanor conviction. As I stated before, using an evidence-based risk assessment tool is compelling and appealing, but that is only true if it is reliable. Nevada's criminal history records are not reliable. Putting unreliable or insufficient data into a predictive tool will result in faulty results and will compromise public safety and the fairness of our criminal justice system. As we stand now, if a tool like the one is being used in the pilot programs were adopted by statute, individuals like John Doe will be released back into our communities, making them less safe. Simply, Nevada does not have the infrastructure in place to support this bill. We are not ready for it. As such, I strongly urge you to consider the impacts of this proposed legislation. And on behalf of my individual capacity as the Washoe County District Attorney, I oppose it. And on behalf as the president of the Nevada District Attorneys Association, I oppose it on behalf of that group. Thank you.
Thank you, Mr. Hicks. Certainly concerning to this committee, as it should be, that our criminal history records are in such disarray, and that's hopefully something we'll be able to work on going forward. I do have a couple of questions for you here from the committee. We'll start with Assemblyman Thompson.
Thank you, Mr. Chair, and thank you, Mr. Hicks, for your testimony. I just want to be clear. So you're saying that in the risk assessment, you do want to see the laundry list of criminal history, correct?
That's correct.
Okay, so my follow-up question is, so at what point, or is that even a standpoint or idea of your district attorney's office to alleviate implicit bias? Or is that just not a concern? Because when you have a laundry list of criminal history and offenses, wouldn't you say that leads to implicit bias? And I'll even use myself as an example, as an African American, dark complexion, named Tyrone, so on and so forth. How does that allow me, if we were trying to look at how do we make this fair, how do I ever get that fair chance?
Thank you. I guess my first response is this isn't my conclusion that criminal history is important to consider. The scientists that study this, that have presented over the year and a half that I was on the commission, presented evidence to us, recurrently stated that it is important to consider this. And so you got to remember the risk assessment tools are being used to predict risk. It's not being used to predict guilt. It's not being used to predict a sentence. All it is being used is to predict risk of reoffense or failing to appear. As far as leading to bias, the only bias I see using criminal history leading to is a bias towards people who have a criminal history. It's very difficult for me to answer it beyond that, sir, because I don't see it in any different way. I don't see it, never have as a prosecutor in my whole life, seen it as someone's name, their ethnicity, their race. That is just simply not something I consider. And so I do recognize, by all means, that the systematic concerns that are often discussed in this committee, and I'm no expert on it. I'm in no position to say, yes, that's so, or no, it's not. But what I can say is I just worry about public safety in this regard. And I just want to make sure that those of which represent a likelihood to reoffend or a likelihood to not appear are being assessed the appropriate bail. And those that aren't, are not. So I hope that answers your question.
Thank you for your opinion.